I'm going to go ahead and call the Derek Johnson case first. Mr. Johnson, I believe your case is eligible for the CU Restorative Justice Program. So I'm going to call that first because we have Mr. Novotny here from CURJ, and he can explain that to you. And Mr. Altenberg, if you know of other cases that may be CURJ, that's the only one that we've flagged. But if we've missed one, let me know.
Yes, Your Honor. We also have Mr. Bettencourt here today, who we have flagged for CURJ as well.
Okay, so let me pull Mr. Bettencourt, if you're here. Why don't you come on forward as well, Mr. Bettencourt, and I'll explain to both you and Mr. Johnson what we're doing with these two cases. So we've got Dylan Bettencourt and Derek Johnson. Gentlemen, with cases that may involve the CU Restorative Justice Program as a plea bargain option, we ask that you go and talk to the prosecutors. You're not really required to just speak to them and tell them anything about the case, but they can share with you the option. And a lot of times people want to hear about that option because it involves a plea bargain that might be favorable to you. So what I'm going to ask you to do is go with Mr. Altenberg and Mr. Novotny. They'll share that information with you about the CU Restorative Justice Program and our court's involvement with that. And then if you decide you want to accept a plea offer from the prosecutor, we'll have you come back in and we'll go forward with that. Or if you decide you want a little more time, you always have the right to have additional time to think about all of this. Okay? All right. I'll see you back in just a few minutes. Mr. Churchick, the charge for you is urinating in public, which is a violation of Section 567 of the Boulder Revised Code. This allegedly occurred on July 18th of 2024 at the 1200 block of Arapahoe. A couple of ways that you could proceed with that charge. You could speak with a prosecutor if you'd like to discuss the possibility of working out a plea bargain. You could do that. Mr. Altenberg's out with someone else, but he'll be back in the courtroom shortly, and he could have a conversation with you. So that's one option. You could also plead not guilty to the charge and set it for trial, or you could plead guilty to the charge directly with me. If you plead guilty, then I would be imposing a sentence in the case. So a lot of different ways to proceed. What would you like to do?
No contest.
You want to plead no contest? Let me make sure you understand what it means when you say no contest. It means that you're choosing not to contest the charge. You're not saying I'm guilty, but you are giving me as a judge the authority to impose a consequence. Do you understand that?
Yes.
When you plead no contest, there's a number of questions that I have to ask every defendant. So I'm going to ask you those as well. Are you choosing to do that voluntarily? Is anybody forcing you to plead no contest? Are you under the influence of any medications or drugs or alcohol today?
I'm on medication.
Any medication that's affecting your ability to think clearly this morning?
No, sir.
Okay. Now, you do have the right to an attorney. You heard me describe that to you a few minutes ago. You have the right to have a counsel represent you if you choose to. You could hire an attorney. You could apply for the public defender. Do you understand that? Are you comfortable going forward without the benefit of a lawyer?
Yes.
Do you understand that a lawyer might do a better job of representing you than you do representing yourself?
Yes.
Do you understand this charge of urinating in public? Do you understand what it means?
Yes.
And do you agree that there's evidence to support that charge? That means that is there a police report or an officer or a witness who could testify at court that possibly you were in fact urinating in public?
Yep. Yes.
Okay.
Your Honor, sorry to interrupt you. Dara said the gentleman might want to speak with her. It might be a community court case.
Well, I didn't realize it. Mr. Churchick, I just have a question for you before we finish up with this. Do you have a place to live?
Yes.
Okay. Dara, you're suggesting that there might be a reason for him to be involved with the community court program. I'm just not sure I understand why that would be the case.
Yes, Your Honor. On the citation, it noted that he did not have an address, and I do see that he has participation from the shelter. So I just wanted to offer that.
Okay. So let me just tell you a little bit about our community court program, Mr. Churchick, before I finish up with this process of accepting a guilty plea. The community court program is one that we offer to individuals who might have challenges relating to housing or other stability related challenges. The prosecutors in our court are willing to dismiss a charge such as a urinating in public charge if you meet with our navigator, which is Dara, and Dara can determine something that you can do to improve your stability. And so in lieu of pleading guilty and having a fine or community service order, you could have your case dismissed if there's something that you can do to improve your stability. secure a new driver's license, get a social security card, apply for a job, those types of things. So if you think it's worthwhile to have that conversation with Dara, you could have that conversation right now.
Okay.
Do you want to do that? Okay, why don't you do that? And then we'll recall the case. You always have the option of pleading guilty if you choose to, but this might be a better resolution for you.
Okay.
All right, thank you.
Thank you, John.
You're welcome. John Toller. Good morning, Mr. Toller. Mr. Toller, the charge for you is obstructing government operations. That's count one. There's a second count of having a prohibited item, which is a tent or a net. Both of these charges were allegedly to have occurred on March 15th of 2025 at 1001 Arapahoe. The documents that I have, the citation indicates that you may not have housing. Is that accurate?
That's accurate.
So it might be worthwhile, just like the last gentleman I spoke to, for you to have a conversation with a navigator this morning.
I actually did bring these to the community court over at Deacon's Closet the other day.
You met them over there on Thursday?
Because it's an obstruction ticket, I couldn't get it taken care of.
I understand that, right?
I did nothing different from any other time I take my tent up. You just decided to give me obstruction.
Okay, so why don't, if you don't mind just having a seat, I don't know if Sebastian's available to have a follow-up conversation.
Maybe he's at the shelter this week.
Okay, he's at the shelter this morning. Okay, so when Dara's back and done speaking with that other gentleman, she can have a conversation with you. Mr. Reynolds, unless you think it's something that you're already ready to proceed on, but I don't know that we have enough information yet.
It would make sense for him to talk to Ms. Amont.
Okay, so just go ahead and have a seat, Mr. Toller. We'll let her know that you're waiting to speak with her.
Sure.
All right, thank you. Eliana Keegan. Good morning, Ms. Keegan.
Good morning.
Ms. Keegan, the charge for you is possession or consumption of alcohol in a public place. This allegedly occurred on February 15th of 2025 at the 1100 block of 13th Street. I'm just going to quickly look in the file. Sometimes I see offers on these types of cases.
Sorry, did you say February?
I did, because it looked like a 2, but it's an 8, and I should have.
No worries.
Yeah, thank you. I'm on autopilot looking at and I saw a 2, but it really was an 8, so thank you for that. It was August 15th of 2025. And I'm pulling up the file because our prosecutors have put a plea bargain offer in the file for you to consider. So let me just take a quick look at this. Okay, so what the prosecutors have said is if we were to, and I don't know if you've had this conversation with them beforehand or if they just put this in the file for you to consider, but they would be willing to dismiss the charge of possession or consumption of alcohol in public if you completed a handwritten 250-word essay. We would continue your case over a couple of weeks. You would submit the essay to the prosecutor's office. They would upload it into our system and they would file a motion to dismiss. If you got the essay to them before your court date, the dismissal could occur before you even had to come back to court. So that's an option from them.
Okay, and I wouldn't have to pay any.
There would be no fine, there would be no consequence. Your case actually would be dismissed and your record gets sealed when it gets dismissed.
Okay,
You want to do that?
yes.
All right, so the next step of the process then for you is for us to actually reset your case.
Okay,
You won't necessarily have to come back, and my expectation is that you won't. What I'm going to ask you to get Mr. Reynolds' business card from him to your left. That's where on the email, you'll email to his office that handwritten essay. So you'll write it out, probably have to scan it in or something to that effect. You can always bring it to his office if you don't have the ability to do that, but we're simply going to reset your case, and we'll reset it about 2 to 3 weeks out.
Ms. Keegan.
And I'm going to authorize Zoom. So even if you had to come back for some reason, you didn't get the essay done and you had to come back, you could come back by Zoom, so we don't have to have you physically come to the court.
Okay.
Once you've heard my advisal, I allow people to return via Zoom. So the next step for us is just to send you right out front. Our clerk's going to get you that new court date. Make sure that you send that essay in enough time for someone to review it and then give you the credit for it and for me to sign off on a dismissal motion. That way you'll have that and you won't have to come back to court.
Okay, thank you so much.
All right, thank you for appearing, Ms. Keegan. Right out front to your right, they'll get you the date.
Okay,
Send you an email with our contact.
okay, thank you.
Luke Ferguson. Good morning, Mr. Ferguson. So the charge for you is trespassing. This allegedly occurred August 13th of 2025 at 1060 18th Street. Do you understand that charge? Take a quick look and make sure I don't have anything in the file on that one. No plea offers yet, but it doesn't mean you couldn't have a conversation with a prosecutor. Sometimes it's worthwhile to have that conversation. You could also plead not guilty and set the case for trial, or you could plead guilty to the charge. What would you like to do?
I believe I'm guilty.
You want to simply plead guilty to the charge? And when you give up when you plead guilty, you're giving up your right to trial and all of the other rights I've described. Do you understand that? Are you doing that voluntarily?
Yes.
Is anybody forcing you to plead guilty?
No.
Are you under the influence of any medications or drugs or alcohol?
Medication.
Oh, I'm sorry?
Medication.
Anything that affects your ability to think clearly?
No.
All right. And of course, you've heard me mention, but I have to go through this with each defendant. You do have the right to have an attorney represent you. You could hire one or you could apply for the public defender. Do you understand that? Are you comfortable going forward without the benefit of an attorney?
Yes.
And you understand that the criminal law can be complicated and a lawyer might do a better job of representing you than you do representing yourself?
Yes.
Do you understand this charge of trespass?
Yes.
It means that you entered or remained on property without the right to do so. Do you understand that? Do you agree that there are facts to support that charge?
Yes.
With respect to your right to counsel and these other rights, I have to make sure that you have the knowledge to be giving up those rights. Did you graduate high school or get a GED?
I graduated high school. Yes.
So you understand the rights that you're giving up here today?
Yes.
All right, I am going to find that it's a free and voluntary decision to plead guilty. It is to the charge of trespass in violation of section 543 of the Boulder Revised Code occurring August 13th of 2025 at 1060 18th Street. How do you plead to that charge?
Guilty.
I'll accept that guilty plea. I'm going to take a moment to read the notes here. I think this was at the Environmental Design Building on campus. And I'm assuming that you are not a CU student, or
No, I was previously, but not anymore.
were you a student in August or not?
No.
Okay. Did they give you what they call an exclusion order when they gave you the ticket or not?
No.
Okay. Mr. Reynolds, anything that you'd like to say before I impose sentence in this case?
Jeff, this police delivery.
Yes.
How are finances?
Good.
Okay. Your Honor, I'd request a waiver of costs here and define, and if he's amenable to it, 4 hours of community service.
All right, thank you for that, Mr. Reynolds. Any comments that you'd like to make, Mr. Ferguson, before I impose the sentence?
No comment.
Okay, so what I'm going to do is impose a fine but suspend it, since Mr. Reynolds has made that suggestion. And I was able to hear your response to his question to you about your financial situation not being great. I'm going to impose a $200 fine. I'm going to suspend all of that fine. I'm going to impose court costs, which are $30. You'll have those to pay. I'm going to have you complete 4 hours of community service. I haven't heard a request. I'm sorry.
Community service fee?
I'm going to waive the community service fee, Nick, since I'm charging court costs. I don't want to overly burden the defendant here. I haven't heard a request with respect to a no trespass order. It doesn't sound like the university issued an exclusion order, but I want to make sure you understand, obviously, the expectations at the university is that I think there are certain buildings that are open to the public, like Norland Public Library is pretty open. I don't know about other buildings, but just making sure that you're not in a situation where you violate the rules there. You're there after hours, things of that nature is what happened here. I'm not imposing an order that prohibits you from going back to the campus or to buildings that you're allowed to go to, but I want to make sure you understand if you came back with another trespass charge, it might be a different response. It's a very lenient response that was suggested by the prosecution and that I'm embracing here, but I want to make sure you're thinking about that as you move forward. All right, so we'll have you meet with our probation officer. You're not going to be on probation, but she's the one that will give you information on where you can complete the community service. She'll give you a deadline for completing that. As long as you get that community service completed by the deadline, then your case will ultimately just close up because we're not putting you on probation. And I am suspending the fine on the condition that you complete the community service. And I think I'm also going to suspend it on the condition that you have no similar violations for 12 months. So technically the case will stay open. You won't have any obligations with us, but that does give the court the authority that if you were to have another trespass charge, you could be brought in and have to pay that $200 fine that I've suspended. Does that make sense?
Yes.
Okay. What we're going to do now is direct you to probation. So you'll make 2 right turns as you exit here and then a left to the end of the hallway. That's where you'll see our probation officer. She'll go over all this with you, give you a deadline for completing the community service. And if you get that to her by the deadline, you won't have any other court obligations.
Okay.
All right. Thanks for appearing here, Mr. Ferguson.
Thank you.
Well, that took a turn. Watching run this municipal docket was like watching someone guide a mix of law class, social work, and light mediation. Structured, firm, but always nudging defendants toward stability over punishment. The session opened with, and both flagged for Boulder's Restorative Justice Program. Instead of pushing for immediate pleas, Cahn explained the option in detail, encouraged them to talk with the prosecutor, and framed it as a chance for a favorable plea bargain that could involve accountability without a record. It was less about hammering them in court and more about opening a door toward repair e-entity, urinating in public. At first, he wanted to plead no contest, but when the prosecutor noted he had no stable address, Cahn paused the process to explore whether he qualified for community court. He explained how meeting with a navigator and taking steps like securing ID or applying for work could lead to outright dismissal, something more constructive than a fine. Instead of rushing to sentence, he rerouted the case into a path aimed at long-term stability. A simile laid out with entity people, John prohibited item charges tied to homelessness. Cahn acknowledged his prior contact with outreach services and held off on moving forward until a navigator could meet with him. It wasn't just about clearing a case, it was about syncing the courtroom with community resources. When Entity 1, Cahn shifted gears. The prosecutor had offered a creative resolution. Dismiss the case if she wrote a 250-word essay. Cahn embraced it, explaining the process clearly and making sure she understood that completing the essay would not only end the case but seal her record. He even authorized Zoom for future hearings to avoid unnecessary travel, showing flexibility alongside accountability. Finally, Entity people, Luc pleaded Guai, Cahn struck a balance. A $200 fine, fully suspended, paired with 4 hours of community service and $30 in costs. He emphasized that the leniency hinged on compliance and no repeat violations, essentially warning Ferguson that this was his one free pass. The directions he gave, even down to 2 rights and a left to probation, showed his preference for clarity and follow-through over intimidation. What ties it all together is Cahn's steady stability paired with alternatives. Whether it's restorative justice, community court, or creative sentencing like essays, he consistently steers cases toward solutions that don't just punish, but aim to prevent repeat offenses. The tone is firm but not harsh, procedural but never cold. Watching him, you see a judge who sees beyond the docket, using the bench not just to close cases, but to guide people toward better footing. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.